Thanks everyone for coming. Looks like we've got a pretty full house and people keep popping in. So to introduce myself, I'm Leslie Howitt. I'm the data analyst for the Utah Indigent Defense Commission, and I'm also the newly elected treasurer for IDRA. So glad to be a part of all of this. With me, I also have Patricia Warth, the director of the New York State Indigent Legal Services, and then John Gross, who's a professor of law at Wisconsin, and also director of the Public Defender Project. So my plan for today is I will begin with an overview of Utah, some of the problems we're seeing, what it looks like. Then I'll hand it off to Patricia for more of an introduction of a more established system and what they've seen. And then finally, we'll hand it to John Gross for a national view, partially based on his 2013 paper that looked at states across the US, and then also just a general view of what things look like in Wisconsin and elsewhere. And then after that, hoping to open it up for general discussion of what people think should be on these eligibility processes and what shouldn't, which I guess I should start there. This panel discussion is about how to determine whether people are eligible for appointed counsel in the first place. So starting with Utah, we have 155 courts here, and as of last year, pretty much everyone was using their own form of indigency affidavits. We use affidavits, which are then analyzed by the judge. Everyone has to start with the state's standards, which are 150% of the federal poverty limit, plus judicial discretion. And so those forms really affected what that judicial discretion looks like. I found one form from Iron County that asked for a defendant's bank account number. Not exactly sure how they would use that. I don't know if they'd go to the banks and say, oh, can you tell me how much money this person has in the bank? Don't know if that's even possible. And then it varied from that to Provo City has an online form where if you enter certain answers, they don't ask you any more questions. If you say you're unemployed, they don't then ask you how much your income is. In the last year, the courts have attempted to create a standardized form. It just rolled out in January, and I think it's already seeing some issues. It's a very long form. And it also asks for, it includes public assistance as a form of income. So they at least knew enough to not include food stamps, but they say, oh, any non-food stamp assistance, please count that as income, which of course we have some qualms about. I would definitely like to recommend a multi-step process, somewhat similar to what we'll talk about New York has, where if you say you're on need-based public assistance, no further questions, and you can just be assigned an agency to save some paperwork. But we're definitely looking for lots of ideas about what this form could and should look like. And so that's what I'm hoping to get out of this discussion today. So with that, I'll hand it off to Patricia to tell us all about the New York State system.
Great. So as many people know, New York State has a county-based public defense system. So that means essentially that we have 58 different public defense systems in New York, plus the city of New York, in addition to that. And on top of that, we have a town and village court system. So when Leslie talked about, having 150 courts, I started chuckling because in New York, we have probably that many sort of town or city court and more superior courts, but we have over about 1,200 town and village courts. So if you think about it, with this county-based public defense system and this town and village court system, we have a lot of courts and a lot of complexity. And so it's no surprise, and it shouldn't be a surprise to people, that, prior to 2016, in New York, there was no consistent way of determining whether somebody was eligible for assigned counsel. financially eligible for assigned counsel. And in fact, in 2001, the New York State Commission on Judicial Conduct, which looks at, how judges make decisions, actually highlighted the problem with this lack of uniformity and consistency regarding determining whether somebody's financially eligible for assignment of counsel, and noted that, quote, among the complications confronting judges in the process of appointing counsel are the disparate eligibility standards from county to county and the varying means by which eligibility determinations are made. So, and then in 2006, a commission that was convened by then Chief Judge Judith Kaye to study and evaluate the state of public defense in New York similarly concluded that there was no uniformly applied criteria and procedures for determining financial eligibility for assignment of counsel, and that the failure to have such a process meant that at times there was outright denial of the Sixth Amendment right to counsel, that people, simply were not getting assigned counsel who should get assigned counsel. So that was the state of affairs until about started to shift in 2014-15. New York actually settled a lawsuit against New York State regarding the state of mandated representation in criminal cases, commonly called the Harrell-Herring lawsuit. It's Harrell-Herring versus the state of New York. And among several things, the Harrell-Herring settlement required that there be standards developed for determining financial eligibility for assignment of counsel. And my office, the Office of Indigent Legal Services, was designated as the implementing agency for Harrell-Herring settlement. And hence we were required to develop criteria and procedures for determining eligibility for assignment of counsel. Our office had been created in 2010 via statute. And, I think the plaintiffs picked up on the fact that our statute itself also authorized us to set forth criteria and procedures. Now, I should note that both the settlement and our statute make it clear that these criteria and procedures that we issue are to guide courts in making determinations as to financial eligibility for counsel. And so it's always been clear in New York, and it was clear when we sort of waded, into this endeavor that, our standards wouldn't have the force of law. We don't have rulemaking ability, that they really are to guide courts in making their decisions. But still, when you have uniform standards, when you have clear criteria, clear procedures, they can be very powerful. And so to sort of go about the process of developing these, we, as a team and as an office, did a lot of work. We surveyed judges and providers, and Andy Davis, who was with our office at the time, may be able to speak to that. We conducted public hearings across the state, a total of 8 different public hearings, in places across the state that would allow for the public, providers, judges, anybody to come and give testimony. And we also allowed for the opportunity to provide written testimony as well. And then, of course, we just did a lot of research. We reviewed existing reports, guidelines from other areas, some of the work that John Gross, and he cited in our commentary and our eligibility standards. So, we used all of this, and as an office really worked hard to develop standards. There were 2, in the work that we did, I would say a few themes emerged that, were very important to us. One is, and I think the most important theme is that financial eligibility for assignment of counsel should not be equated to destitution or indigency. And we were fortunate in the course of our work to stumble upon a memorandum that was written in 1977 by an appellate justice and issued to all the courts within his jurisdiction, the 3rd Department in New York, where the justice said in this memorandum that financial inability to afford counsel is not synonymous with destitution or a total absence of means. nor are standards used to determine indigency for other purposes controlling. He went on to say, a person charged with a crime or before the family court and otherwise entitled to assigned counsel is eligible for assigned counsel when the value of his present net assets and his current net income are insufficient to enable him promptly to retain qualified attorney, obtain release on bond, and pay other expenses necessary for an adequate defense, while furnishing himself and his dependents with the necessities of life. Bingo. That became our core standard and our guiding principle in determining and setting forth our criteria and procedures. The other theme that emerged is many people spoke about the value of having presumptions of eligibility as a way of both streamlining the process and ensuring that you're not requiring an overwhelming amount of information from people that makes the application process burdensome. A third theme that emerged is the need for confidentiality. And many providers told us that, of stories where, information that was conveyed during the assigned counsel application process was sought after by the prosecution in order to investigate possible charges against a person. And clearly, somebody should not be subjecting themselves to a possible criminal charges because they don't have the means to obtain counsel and to exercise their Sixth Amendment rights to counsel. And so, we were determined to ensure that the application process is confidential. Finally, one of the things that was often discussed during the hearings themselves was whether or not fraud is a significant issue. And what we kept hearing over and over again is fraud is not a significant issue. And by that, I mean, it's not common that people engage in fraud in order to attain counsel, assigned counsel. And in fact, most people told us that people can afford counsel to retain counsel. They get counsel. They want to be able to choose their own lawyer. And so fraud is not a significant issue. But still, we had a lot, as you can imagine, a lot of public officials telling us, you have to beware of fraud. So in sort of, thinking about all this information, we ended up with two, I would say, guiding principles in our standards. One is ensuring that the standard that is set forth in that memorandum language that I just read to you, that not indigency, not destitution, but inability to pay and maintain, continue to maintain, support the people you need to support and have a car, have a house, all of those things, that needs to be the standard, right? Inability to retain counsel. And second, another guiding principle was that people need to be able to have counsel as soon as possible. The right to counsel can become meaningless if people are not assigned counsel as soon as they need it. And so it was incumbent upon us to develop a process that ensured access to counsel, as soon as somebody really needed that, as soon as somebody needed counsel, even pre-indictment or pre-arraignment if necessary. And for family court cases, pre-petition. And so those were our standards. I'm not going to go over all of our standards, and I don't know, Leslie, I'm happy to email them to you, and then you can share them with this group. They're also available on our website. And so I would encourage people to go to our website. But I would say that the core part of our standards are, one, the presumptions of eligibility. And for presumptions of eligibility, they're pretty straightforward, right? We have an income level presumption. So if somebody's net income is at or below 250% of the federal poverty guidelines, they are presumptively eligible for assigned counsel. Two, applicants who are incarcerated, detained, or confined to, mental health institution are also presumptively eligible for assigned counsel. The theory being, if you're confined, you can't work. And if you can't work, you don't have income. So Third, that applicants who are currently receiving or have recently been deemed eligible for need-based public assistance are also presumptively eligible for assigned counsel. And for us, that was a bit of a no-brainer. Somebody else has already determined that you need assistance, you need financial assistance. And if you need financial assistance, you certainly don't have the resources to retain private counsel. And we also tried to honor what the Cade Commission had found, that decisions were being made varied from jurisdiction to jurisdiction, and in a way is sort of trying to show that that shouldn't happen. We also, as a presumption, noted that applicants who have within the past 6 months been deemed eligible for assignment of counsel in another case or another jurisdiction should also be presumptively eligible for assigned counsel. So those are our presumptions. Other aspects of our procedures that I'm more than happy to talk about, when people have questions, are what we say about non-liquid assets, for example, what we say about third-party income, what we say about the ability to post bond, all of those issues, as well as some of our procedures. So for example, again, a statement that people should have a decision made about their eligibility for assigned counsel, at the point that they need it. And so including pre-arraignment or during an investigation stage of a criminal case or a family court proceeding. And similarly, what we say about the confidentiality of information provided and how that's maintained. So I'm happy to answer questions during the opportunity for questions and answers. I should also say, there needs to be work in implementing standards. My predecessor, Bill Leahy, has often said, and he's very accurate about this, that laws, standards, they're not effective. There needs to be work for implementation. And so, we set forth our standards in April of 2016, and over the next several months, we engaged in a lot of work on training providers of mandated representation, as well as just judges and justices. And so we were on the road a lot. I see that Lisa Robertson, who is the ILS eligibility attorney, is on this call, and Lisa can talk about, her travels across New York State to do trainings for both judges and mandated reporters. And we're willing to continue to engage in training. And we have. The other thing is the settlement, the Harrell hearing settlement itself requires that we produce annual reports about implementation of the standards in the 5 counties. And I think that these annual reports can be incredibly helpful in sort of what happens when you implement progressive standards. And, the lessons that we've learned are, that one, it actually makes, the administrative burden is alleviated for a lot of people because of the presumptions of eligibility. And so you're not, trying to get a lot of papers that aren't necessary, a lot of documentation that isn't necessary. And so it really makes the process more streamlined and allows you to focus on the sort of close calls, if you will. We also found, and this is most interesting, that while there's probably been a marginal increase in the number of people deemed eligible for assignment of counsel, it really hasn't been overwhelming. It really hasn't been that significant. The real significance of our eligibility standards is that people are assigned counsel much sooner in the process than they previously were. And, in the 5 counties, we repeatedly are hearing that people aren't coming to court time after time after time while their application is pending, right? People get counsel right away. And from our perspective, that's probably been the most significant impact of our eligibility standards. The other impact, I think, is that because in New York, in most jurisdictions, the providers do the screening, because they're not asking people for needless paperwork. They're not sort of constantly butting heads with people about, eligibility for assigned counsel, right? So like in one of our counties, for example, if you were homeless, you'd have to produce an affidavit of homelessness. In another county, if you were applying for, yeah, John's laughing. I probably imagine that. If you were applying for assigned counsel in another county, you had to get an affidavit, a financial statement from every single person who lived in your household. And so, it was this constant tension between, applicants and the providers who were doing the screening. And since our standards have been issued, since the counties have been implementing our standards, they say it's just a much more streamlined process, and they're not constantly butting heads with applicants. So, I'm happy to answer questions, but I think John was going to talk, and then we'll move to discussion. Is that okay?
Yeah, that'd be great. Thank you so much for that introduction. I've definitely found it really interesting and useful to look at yours, and also the commentary on it that you guys have written, which I think would be, for anybody interested, that's definitely the document to go look up, because it provides information on how you came to all of these decisions. But yeah, John, if you wouldn't mind taking the mic.
Sure. Can everybody hear me? Okay, good. So I'm part of the conversation, I guess, because what seems like a long time ago, I was working for the National Association of Criminal Defense Lawyers, and I wrote a series of reports for them when Gideon turned 50. And one of those reports was about indigency standards, and it was entitled Redefining Indigents Financial Eligibility Guidelines for Assigned Counsel. And it's still on. I just checked NACDL's website. You can just go to their reports section and scroll down. There's a lot of good reports there, actually, on a variety of things. But this is something that we wanted to do to make available to indigent defense providers across the country, because essentially what I discovered, as you can tell from the headline, was that a lot of states were just relying on some percentage of the federal poverty guideline to decide whether or not you were entitled to assigned counsel. And any economist will tell you that the federal poverty guidelines are, and I believe it's a technical term, garbage. They do not actually reflect real poverty. They're not even close. And I go into the history a little bit of them in the report. So if you're interested in learning more there, you can go there. You can Google it and find lots of information about it, frankly. It was a surprise to me at the time, because I was not an economist, I was a lawyer. And I thought that these guidelines had some, fact-based evidentiary grounding. And when you go back in time, they do not. They were made in the 60s. They were based on a sort of cocktail napkin calculation about how much money could you spend on food to not die, the thrifty food plan from the Department of Agriculture, combined with, in general, what percentage of household income goes toward food. And those two things were slammed together by an economist named Molly Orshansky in Lyndon Johnson's War on Poverty to come up with a ballpark estimate of who is poor. Those guidelines have not been changed to reflect actual consumer prices since they were called into existence. They're only adjusted for inflation, and so they're wildly inaccurate. And as you can tell, as Patricia mentioned, they're still used. I mean, they're used for a variety of federal government programs. And New York State eventually adopted a 250% of the federal poverty guidelines standard. But many states are using the guidelines, or 125% of the guidelines, or 150% of the guidelines. And so I can tell you that in Wisconsin, you are eligible for free school lunches and help with your home heating during the winter, but are not eligible for assigned counsel. based on how they use the federal poverty guidelines. So that's the first thing everybody needs to be aware about. If you're having these discussions with judges, with policymakers, you're going to need to educate them a little bit about where these guidelines came from and how wildly inaccurate they are in terms of capturing who is in poverty. And I'll echo Patricia's comments about this too. The standard here is not indigency. The standard is too poor to hire a lawyer, and I will add, too poor, right, to adequately present a defense. So we're actually not just talking about the lawyer, right? If you've got a case where there's DNA evidence, where there's an accident reconstructionist, where there's complex medical testimony, right? Those are additional factors that need to be considered, because if the defendant is going to need to retain an expert to adequately defend the case, it's not just the cost of counsel, it's the cost of the entirety of the defense that needs to be thought about. So that's another consideration. Another issue that came up quite a bit is what about the defendant making bail? If the defendant makes bail, are they ineligible for assigned counsel? And some states take this approach, still take this approach, or at least factor in whether or not someone has made bail. This is a position that has explicitly been rejected by the American Bar Association in their standards on criminal justice for the very obvious reason somebody else can pay your bail, right? Your mom can pay your bail. Your cousin can pay your bail. It doesn't mean you have the money to afford counsel. And even if you do have the money to afford counsel, you cannot be forced to choose between bailing yourself out of custody and retaining counsel. That you don't get to decide, right, which constitutional right the defendant gets to exercise, okay? So this idea of how does the ability to make bail, or the fact the person made bail, this is another thing I saw repeatedly in the report and is still sort of a stumbling block, especially for some judges, when they look at someone and say, well, they made bail. Well, judge, again, you have to have conversations with them about this. Once you start exploring this issue, I think it's pretty obvious, right, that the federal poverty guidelines aren't good metrics, that just because somebody made bail doesn't mean they're ineligible, right, for assigned counsel. One other big issue that came up around this, and a lot of states are interested in trying to recoup costs of counsel. And so one of the terms I will introduce to everyone here is the marginally indigent. Okay. So essentially the Supreme Court, when they decided Gideon, right, they set up a binary system. Either you're too poor to afford counsel or you're not. Now that isn't the real world. Some people have some money, but not enough to provide for a complete defense. And so a lot of states have gotten into the business of defining who is marginally indigent and who therefore are required to pay some fee or some part of the cost of their defense. So in other words, if you're not completely indigent, we will make you completely indigent by the time your case is over. I think this is a very bad policy decision. I think it's unwise. Can I come up with a constitutional argument for why states can't do it? Not really. But a lot of states like this idea. And also in states where they do try to recoup costs, they do a terrible job of it. Because you can't get blood from a stone. And frankly, in a lot of places where I see they attempt to recoup costs of providing counsel, I honestly think that the processing and the attempt is more expensive than the amount of money that they get at the end of the day. So it's a bit of a fool's errand. Couple other, just one or two other things I'll mention, and then throw it open for questions and discussion. I agree with Patricia about the whole fraud thing. I've often encountered actually members of the private bar who claim there's a lot of people who would pay for private counsel, but lax enforcement and lax standards about indigency mean they stay with the public defender. There is a tiny, tiny bit of evidence to suggest that some people who are marginally indigent might self-select. So by that, I mean, if you might be able to raise the money for private counsel, you might choose to do so if you think you have a triable case. However, if you do not, and you think your best option is pleading guilty, you're perfectly content to allow the public defender to represent you. But let me stress, the evidence for that is not significant. And the evidence that does suggest that happens, it happens in a very, very few cases. I like to point back to the actual Gideon decision and one of the phrases that the court used in that decision when they were justifying giving people the right to have counsel. They said, to paraphrase, there isn't anyone who can afford to hire defense counsel who doesn't go out and hire the very best defense counsel that they can afford, which the court said is clear evidence. Lawyers are necessities, not luxuries. They're super important. I come back to that language when I discuss this topic with people, with legislators or policymakers. I say to them, what do you think the reputation is in your state of your indigent defense providers, your public defenders? And sadly, right, we all know that we are often not viewed as the best option for people. Private counsel is seen as better. So I say, look, if that's how people view the public defender, who has the money to hire counsel who says, you know what, I'm just going to roll the dice with the PD's office or this assigned counsel who I've never met before and I don't know how much they make, right? So I think that's all I have to say about this in addition to Patricia. I'll just add too, and this is in my report, and they're still doing this at the University of Washington. The University of Washington, I forget which department it is. It's one of their departments that actually studies poverty and social welfare. They routinely publish what are called self-sufficiency standards. And these are real economists who are looking at specific geographic locations and calculating how much it costs to afford housing, how much it costs to support a particular family of 2, of 3, of 4, how much daycare costs if it's a single parent working. These are very granular studies about how much money someone has to make to be self-sufficient. And by that, they mean not getting government benefits to keep the lights on and keep food on the table. And if you look at those and you compare them with the federal poverty guidelines, you will be blown away. You will realize how out of touch the federal poverty guidelines are. And I guess the last thing I'll mention about those two, you guys all know, they apply to the whole lower 48. Alaska and Hawaii get a modification, but you are considered poor, right? No matter what geographic location you are in this country based on those standards. And so they make no distinction between New York City and upstate New York, none at all. And so it should be obvious if you spend any time delving into this issue that these are not workable standards, and they should really be taken with a grain of salt across the board when we talk about their usefulness when determining who should be eligible for any type of benefit, let alone something as important as counsel.
So I just want to play in what John said, because everything he said is in the commentary in our standards, because we read your work, John. And so, I know that I said we use the 250% FPG as a presumption of eligibility. I want to say two things about that. One, that number came from the self-sufficiency standards. And we had some very helpful testimony during the public hearings that, one, made us aware of the self-sufficiency standard, but then how to easily translate the FPG or the self-sufficiency standard in New York to the FPG so that it would be easier. Do you see what I'm saying? But the second thing I want to say about our presumption is it is just that, because everything John said about the insufficiency, if you will, of having sort of one number, it is absolutely true. And our providers tell us that there are people whose income is above the FPG 250% mark, who still do not have the resources to hire attorneys. And so under our standards, they're required to explore further, even if somebody, is not presumptively eligible. With regard to what John said too about, trying to recoup expenses, particularly as he said, I think he said it really well for, marginally poor people. There is a statute in New York that sometimes people have used to try to do that. Judges have used to try to do that. We have a standard that addresses that issue. And it's pretty clear in our standards that, that's a bad practice. And so, but a lot of, our standards also address exactly what John said about, the ability to post bail. Just because you can post bail, or just because you do post bail doesn't mean that you have the ability to pay for counsel. And so, all of that stuff, if you want something in writing that, replicates what John said, you can find it on our website in our standards with commentary. So you'd have to look at the commentary for some of that. I should also say too, we're pretty clear in the commentary of our standards exactly what John said. And this is so true now, that the ability to pay for counsel really is the ability to pay for defense. And so we make it clear that in making that determination, you need to take into account not just counsel, but also investigation, social workers, all of experts, all of the things involved in a defense.
Great. Thank you both so much for a very thorough and both still service level examination of what these look like. So I'd love to just open it up for general discussion now. I think the best way to move forward until proven otherwise is to just have audience members just unmute yourself and ask your question or make your comment. So let's try that.
I'll ask a question. First, I just want to thank both of you. I really learned a lot already. Well, I really like the framing that it isn't, is someone too poor, too indigent, is can they afford a lawyer? And one thing we've started talking about is what does it cost to afford a lawyer? And I feel like that's something that's very missing in a lot of these conversations. So have you either of you looked into that? Like, how do you figure out, like, well, what does the average lawyer cost? Is there any sort of way we could incorporate that, or how do we go about learning that to make that part of the standard?
Here's what I'll say about this, and this was something that I learned when I was working for the National Association of Criminal Defense Lawyers, because prior to that, I was a public defender and never really thought much about what a lawyer would charge. The reality is if you talk to private criminal defense lawyers and you ask them how much does a particular case cost, they will say that depends. And it depends largely on how much money the person has, sadly. And maybe that's not sad, though. When I talk to them about this, they're really quite frank about it, which is they say, look, they need business. They need to earn a living. And if somebody comes to them with a case and they can only pay $2,000 or $3,000, then that's what they charge them. But if the similar situated person with the same charge comes to them and they believe they can spend $5,000, they charge them $5,000 for it. And so they don't really have a menu of rates. And it can depend a lot also on how busy they are at a particular time, whether they decide to take a case and how much they'll demand to take the case. But this also reflects something else, which is not part of our discussion today, but that private criminal defense attorneys often also take assigned counsel work, and they are drastically underpaid for their assigned counsel work. And so it is my belief that what happens is that by artificially underpaying criminal defense attorneys for handling indigent defendants, people too poor to hire lawyers, I should say, what the government is doing is inflating the cost for people who can afford to hire lawyers, which is an economic discussion for an entirely different day. I think it has its own complexities, but I mean, you can survey them about sort of an average cost, but it's going to vary. It's going to vary. And I do really believe that they try to profit maximize, because if they take assigned counsel cases, they're being paid oftentimes just overhead at best. And so they really need to maximize their revenue when they have somebody who can pay for counsel.
The other thing I would add to what John said is when we started rolling out our eligibility criteria and procedures and our eligibility standards, we were getting a lot of questions about, well, how do you determine how much it costs, to provide to provide a defense, right, in cases. And we did reach out to private counsel to try to get a sense of how do you determine that. And we pretty much learned exactly what John just said. Private counsel don't have, they tend not to have payment scales. It really varies from case to case and person to person and situation to situation. And frankly, it should. And so, we just, we probably didn't answer that question very well during the trainings when asked. But what we've learned over time is this: in 85 to 90% of the cases, people are deemed eligible because of one of the presumptions of eligibility. So in 85 to 90% of the time, you don't even have to think about that issue. And then in that additional, probably, 8 to 10%, you're going to learn that somebody might have some disposable income, but it's so de minimis that they won't even be able to pay for traffic ticket representation, right? I mean, there's just very little money. So it's really very seldom that you have an applicant where you're really sort of needing to determine, that they do have some resources that, might be sufficient enough for you to think maybe they can pay for counsel. And in those cases, you might have to call around a little bit and ask private attorneys, Usually what providers tell us, though, is that they have a sense from their own experience in the county, or they know somebody. Usually there's somebody in their office who used to do private work who can really tell them if the money that the person has is sufficient. But the bottom line is you're very, very, because the people who apply for counsel really tend not to have resources, you're very seldom actually having to figure that out.
The one other consideration I'll add to this is that one thing you have to realize too about private counsel is they will not take a case on some type of an installment plan. Okay. They're not ethically permitted to take a contingency case, right? It's unethical to do that. And the likelihood that somebody might become displeased with their representation or upset about the offer that they're getting means all private criminal defense attorneys want a lump sum payment up front. So we're not talking about somebody who maybe has $500 in the bank and maybe every month can put together an extra couple $100. No, we're talking about they're not entering an appearance on a case unless you have $3,000 or $4,000 or $5,000 that they can put in escrow and draw on, right, to pay their fee. And so I think it's important to note, even if somebody is generating some disposable income every month, it's not going to be enough, right, to draw in a private defense attorney unless they can make a large upfront payment.
Katrin Johnson, go ahead.
Hi guys, thank you so much for everything today. This is so interesting. I wanted to just add a little bit on the surveying of attorneys, private attorneys, because we have some experience in that. Then I have a question. We've done 2 different surveys in our office of private counsel, and I'll tell you the first one was just crazy because attorneys would say it ranges. A DUI can be $5,000 to $50,000. Because as attorneys, you're thinking about the case that goes to trial, hung jury, comes back. And so the second time we did our survey, and so this was sort of a lesson we learned, is sort of we asked first the average cost per case that doesn't include trial or complex litigation. And then separately, what would it be with trial or complex litigation? And we got much more useful data breaking it out that way. And like John was just saying, we asked the question in there too about how much is required up front. And what we found is what we were able to say is over 70% of our respondents indicated that they need at least 50% upfront. And so we put that out there in bold to give courts that context as well. So that was our lesson learned on that. The question I have though is about the confidentiality piece in COVID. Because with so many court hearings online now, what used to be the form that people would fill out, you'd have the confidentiality. Now in this new remote world, instead there's the questioning happening virtually online in front of everybody in the world. I'm just curious if you've seen any good best practices out there for how to handle indigency screening during COVID.
Ideally, you have a screener and that the screening is not done in court, that the screening is done before the court proceeding. And so that's what's happening across most of New York, is most instances, you know, and I should add that as part of implementation of the eligibility standards, New York, pursuant to the settlement, was also obligated to ensure defense representation at everybody's first court appearance. And so the two are tied together in facilitating that the screening can happen, you know, around the court appearance when you first see somebody, but it doesn't have to happen during the court appearance. So usually before or after, immediately after. And so that's what I would encourage as a way around that issue. We did actually have a provision in our standards that said screening shouldn't happen in open court, and judges objected to that. You know, they're like, you can't parse off a part of the court proceeding and make it, you know, ex parte, like, except they do all the time. Let's just be honest, like they do, you know, but, you know, so our response to that is then, okay, no screening in court. And mostly it's worked.
Yeah, my opinion is judges don't really have any business doing this. This should be handled by the indigent defense provider or a sort of neutral third party pretrial services unit that screens people, and all of the statements made during that screening should be confidential. You know, particularly if somebody's being charged with a financial crime, like some type of welfare fraud or drug dealing, right? Sources of income take on an entirely different aspect. And I always find it puzzling when judges do inquiries about eligibility. You know, I typically see things like that occur with no context or, you know, no introductory remarks from the judge about why these questions are being asked, you know, what impact they have on the case, and no understanding of, right, like what procedure is happening at this point. But I will say, and I think this mirrors Patricia's reaction to judges in New York, is that I have often found when judges are used to doing something, the suggestion that they stop doing it is taken by them as a threat to their control over their courtroom, right? And they react by saying, but I know what's best. So I should choose who gets to get representation, and I should decide who represents them because I should run my own courtroom, et cetera, and I decide how much people get paid, all that stuff, right? When you actually wrest control of that away from the judge, they suddenly realize, oh, I never should have been doing that in the first place. This makes my life much easier. The challenge is convincing them to give it up. But once they give it up, they're like, oh, thank God, this is much easier. I have much more time to do judicial things, like set on reasonable bail. But you know, I think that's the challenge with reforming these things, is that if it's become an entrenched part of the court's procedure and it's something that the judge has been given dominion over, suggesting that they relinquish control of that to some other party is perceived as a threat or a questioning of their authority. And that's really what you have to work around to get them on board with shipping this out to somebody else to do.
Yeah. We were lucky in New York. Most judges had already been delegating the screening function to the providers. We did have some judges who, you know, weren't and who were doing it. And over time, you know, sometimes what John is saying, wrestling that from the judges, he's exactly right. But if you're persistent over time, you can get it away from them. And then he is exactly, that's been our experience in New York. The judges, in two issues. One, judges were like, the judges who had been doing the screening, once they were started, told that they shouldn't be doing it, that the provider should be doing it. Initially they were resistant, but over time they're like, oh my God, why was I ever doing that? There's like all this work I had to do. Now I can go golfing on Friday. And then the same is true with having counsel at arraignment. We had judges who were like, I'm totally can handle this. I don't need attorneys here to help me. And over time now that, it's becoming entrenched that there's defense counsel at arraignment, more and more we're hearing judges say, oh my God, thank God counsel is there. It just makes my job a lot easier. So, persistence, don't give up. When you initially don't succeed, just keep persisting and things can eventually change.
We're waiting for questions. Definitely some concerns we've had. It hadn't even occurred to me, honestly, to have attorneys be the screeners until reading your standards. And I think one concern we have is our public defenders are so overworked that when you put the burden on them to decide, okay, this person's marginally eligible, but it will mean an unsustainable caseload for me. That's a hard decision for somebody to make when you also want them to be zealously defending someone.
Yeah, well, our standards actually pretty much say exactly what John just said, that ideally you have an independent screening entity that can do everything required and maintain the confidentiality of the information. But if that's not available, which in most New York places it's not available, then our standards say the provider should do the screening. And, in New York, part of the reason we came to that decision was because in most places, providers were already doing the screening. And so it wasn't hard to implement that. But you're right, it does, it is an administrative, burden for providers to do the screening. The one thing, though, I would keep in mind about it is, the providers who do it have told us that there's a couple benefits to doing it. One is they're the first contact with the client. And that's good to be the entity that has that initial contact, right? To have somebody who's on your side be the person, who you're talking to about some of these personal issues that are involved in screening. And second is providers are in the best position to maintain the confidentiality of the information that's disclosed. And, many of our providers use the eligibility screening. They actually sort of weave it into their intake form, which they consider to be privileged and confidential information. And so it's really sort of, enhanced the confidentiality of that information that's disclosed during the screening process. And as, and it's also streamlined the gathering of information.
And Leslie, I think there's a flip side to the concern that you raise about, say, the public defender who is concerned about caseloads, right, doing the screening. With that in mind, right, if I am the indigent defense provider and I am making the representation to the judge that I believe that the person qualifies, I should be entitled to great deference in making that decision, right? Because the judge knows that I have a lot of cases, right? And so if I'm saying this person qualifies for my representation, admittedly, there might be incentive for me to say that they don't if I'm trying to regulate my caseload. Another aspect of that too, and I can speak to this from personal experiences, I would imagine that there's a large number of public defenders who would do the opposite. They would look at a person's case, and if they thought the person was, say, marginally indigent, and might be able to retain counsel, but knows that that bill that they will get will be disproportionately large, right? That they will have to pay thousands of dollars to resolve a first arrest case where the public defender knows there's a standard offer from the prosecution that will result in diversion. The public defender must just say, I'll take the case. And I'm speaking from personal experience on that one. As a public defender in New York City at the start of my career for almost 8 years, if I had somebody with a first arrest and I looked at their financial eligibility and I thought they're borderline, but I know I can walk in a court with them on the next date and get them a disposition that doesn't give them a criminal record. And I say to them, is that something you want to do? And they say yes, they qualify. Even if I might not be looking as hard as I should be into that actual eligibility, because I'm going to be in that courtroom anyway that day, handling 10 other cases. So the additional workload to me is so marginal, and it will save this person $3,000 or $4,000 or $5,000 when I know, right, the state is making these unreasonable determinations about who is too poor to hire a lawyer. So I'm thinking about public defender mindset a little bit. And occasionally you might get a guy who's like, I got too many cases, I can't deal with people. I'm going to say they don't qualify if they make $1 over the standard. I think more often than not, the people who are doing this work are going to bend the rules to help somebody who they think is not going to increase their workload and would be severely economically disadvantaged if they had to retain private counsel.
That makes a lot of sense. I think if anyone's got a last question, we probably have time for one more before we have to drop off. Okay, well, that looks like that's probably it for now. Thank you so much, Patricia and John, for being willing to join this panel and sharing all of your wide expertise. That's been incredibly useful for me, and I hope for everyone else. And thanks to everyone for joining us and the Decent Center for hosting.
Thanks, everyone.
Thank you.
Good job, you guys. Goodbye.